Hi, this is elder law attorney Melissa O'Connor. I create estate and Medicaid plans for people in Florida. If you have a question, drop it in the comments below. Today I wanted to talk to you about incapacity and guardianship proceedings. Sometimes I have families come to me with great concern. Their loved one has medical conditions that are alarming. They believe that there are some memory problems and capacity issues. These relatives do not have any sort of plans in place, meaning no durable power of attorney, no medical health care surrogate designations, and their loved ones are beginning to get very nervous and feel as if their hands are tied because they have no way of helping this relative of theirs that they see declining. And the concerns many times are, it's not that bad yet, right? But I have great concern. And they're also in a stage in their disease where they are not seeking help. They're actually like self-sabotaging. Like they're refusing good suggestions, they're refusing all help, and family's getting quite alarmed. And so now they come to me and they want to talk about guardianship, but they think that their loved one may just not be there yet because they know what day of the week it is, they know who the president is, things of that nature. So they're like, I think that, they won't fail that cognitive test. And so we have questions about where they are in the progression of the disease. And some of the things that I want folks to fully understand is that you can petition for incapacity, and it does not mean that they will be deemed to be completely and totally incapacitated. Rather, a court may find that they have limited incapacity. So they need a limited type of guardianship, meaning certain rights they will be able to retain, and other rights the court might find it's in their best interest to delegate to somebody else, especially the right to make medical decisions and the right to handle their money and their finances. The court might find that they can still vote in a public election. The court might find that still can decide who they socialize with. The court might find they can still determine where they live, their residence, all those types of rights. And so families sometimes don't understand that there is this limited alternative. It's not just all or nothing. And so when I petition for a determination of incapacity for folks who have concerns about their loved one, and they don't think that they're completely disoriented. They're like, they're not totally incapacitated, but here are my big concerns. My big concern is they decided that they were gonna just gift their nail technician $6,000. And thankfully that nail technician was a good person and gave the money back to the relative. Like she said, your sister just gave me a check for $6,000. I feel really odd and uncomfortable at this. I don't want it. I'm just going to give it back. Can you rip this up? And, because she refused to take it back. So that's alarming. Like, why are you giving your nail technician gifts of $6,000? There were concerns that maybe neighbors were like hitting them up for loans, and these neighbors are not creditworthy. There were concerns that a trip to the grocery store ended up them 2 counties over and law enforcement having to bring them home. They got disoriented and lost. There were also concerns sometimes people express because there's a recommendation that they go for an appointment with neurology and start to have things take a look at and see if maybe we are experiencing some sort of cognitive decline and maybe medication and other treatment options are available to them. And they just freeze and say no, that there's nothing wrong and they're not going to be seeking any additional medical treatment. And in fact, now they stop going to the doctor altogether because they don't trust doctors at all. Those sorts of behaviors are things that should alarm families. And if you're not able to gently convince, redirect, assist your relative in a supportive way, so that way they can still make these decisions themselves and help them, guide them, if they're refusing all support and think they got their whole life under control, and you know that they're going to be getting lost the next time that they go for a drive, that's your big concern. Next big concern is that the next person that they decide to give $6,000 to will take it and won't be such a good person and give it back. Those are legitimate concerns, and that might be something that you want to petition for guardianship based upon, because you want to protect them from people. Now they're a vulnerable adult subject to possible exploitation. So that might be a reason to file a petition and start the guardianship process. These processes are all very personal to you and your family because it's a big thing. You are having a court remove rights from somebody and delegate them to somebody else. So that's not something that we want to take lightly, but it's also something I don't want you to think that is impossible simply because your loved one knows what day of the week it is and they know who the President of the United States are. Those aren't just the two goalposts of whether you have capacity. And I would like families to know that, so that way they are aware of options and tools that are out there to protect their relatives and to assist their family in getting good care for their loved ones. If this information has been helpful, I ask that you like and share with others. And as always, you can schedule a free strategy session with me at eldermeeting.com. Thanks for joining me.